Hello students. Be ready for the dictation. 31. In view of the nature of this case, as observed in Mantu Sarkar's case, Supra, we would have even exercised our extraordinary jurisdiction under Article 142 of the Constitution of India to do complete justice between the parties by determining the question of compensation, as the accident in question occurred on 7th March 2006. Despite the death of the son of the appellant in the said accident, the fact is that the claimant did not get compensation despite the passage of more than 18 years. We have already noted that all relevant issues were framed by the tribunal for the purpose of determination of compensation. However, even after deciding to permit the parties to adduce evidence, the tribunal in the instant case appears to have confined it for the purpose of deciding the only question of territorial jurisdiction, and therefore, in the absence of evidence on necessary ingredients for determination of compensation payable, we are not in a position to determine the compensation, as, in view of the factual position obtained in the instant case, sufficient to apply the decisions in Mantu Sarkar's case, Supra, as also Malati Sardar's case, Supra, to reverse the finding on territorial jurisdiction. The High Court has fallen in error in not picking up the illegalities resulting in failure of justice and to resolve them appropriately. For the purpose of determining the compensation, in respect of a case of this nature, the relevant factors and dates necessary for computing ultimately the quantum of compensation are not available on record before us. Though we are pained and peeved, but we have no option to remand the matter after a long period of 18 years. Taking note of such circumstances and the prejudice already caused to the claimant, and further that, directing the Motor Accident Claims Tribunal at Nainital to restore MACP number 137 of 2006 and fix a date for the appearance of the parties, and then proceed to consider the question of grant of compensation, ignoring its finding on territorial jurisdiction. As they had already examined witnesses before the claims tribunal, we are inclined to remand the matter to the Motor Accident Claims Tribunal at Nainital. We hold that it would not cause any prejudice to the opposite parties, as they have already filed the written statements before the tribunal, despite objecting to the territorial jurisdiction, and even thereafter have chosen to adduce oral evidence before the tribunal to some extent. It is also a fact that the First Respondent Insurance Company got its office in Nainital, or in other words, it is conducting its business within the limits of Motor Accident Claims Tribunal at Nainital, and the fact is that cross-examination of witnesses were done on its behalf as well. There cannot be any doubt with respect to the fact that the subject matter of claim is within jurisdiction of the Claims Tribunal at Nainital. Para change 32. For all these reasons, we set aside the impugned judgment and order dated 28 November 2016 passed by the High Court of Uttarakhand at Nainital in appeal from Order number 414 of 2010 arising from the award in MACP number 137 of 2006, and also the award dated 6 October 2010 passed by the Motor Accident Claims Tribunal at Nainital. To enable the tribunal to proceed further and to decide the claim petition on merits, MACP number 137 of 2006 is restored into its file, and in view of the long lapse of time, there will be a further direction that the tribunal shall conclude the entire exercise after permitting parties to adduce further evidence, if any, within a period of 6 months from the date of receipt of a copy of this judgment. Thank you, students. Over.